So we're going to talk tonight about what is advocacy, who advocates, why we advocate, where we advocate, when and how. And all of that I think will be demonstrated as I talk to you about my advocacy and how that started and what I did to advocate for change and to make a difference. I think any advocacy has to involve passion. And one definition of passion is a strong feeling of enthusiasm or excitement for something or about doing something. Because if we're not passionate about it, I don't think we're really going to care whether we advocate for it or not. I can tell you that my passion was in the love that I have for my son. And that love is definitely my passion, the passion that got me started and the passion that keeps me going. Because without it, I don't think that I could carry on. I know that I am very grateful tonight, as Jason was expressing his gratitude, for the opportunity to be here in this class with you all and to share with you how the life and death of my son has changed a lot of lives, including my own. These are some pictures of Casey, pictures that I needed to go back and look at after Casey passed away because I needed to remember those happy times. I needed to have happy memories of him. And it was really hard at first to remember any happy times. In fact, even now, I continue to struggle with that some. It gets better, but it's still difficult. As you can see in the picture there, or in those pictures, Casey was involved in a lot of different things. He was a very active little boy and had a lot of interest. And even though he was, like I said, he was interested in so many things and so many activities. I mean, he was in junior wrestling and softball and basketball and taekwondo and all kinds of activities, things that you would think that would keep someone from maybe getting involved in drugs. But as he got older, all of those things started to fall away. And he lost the ability to be happy. You know, every time that Casey overdosed, that he was able to talk, he said, "I'm sorry, Mom, I'm sorry, Dad, I know I'm a big disappointment to you." And we would always say, "No, you're not, Casey, we just want you to be happy." What we didn't realize was that Casey had lost the ability to be happy. And so there was a lot that we did not know about Casey's disease that we came to know after the fact. One of the things that I learned after the fact was that addiction is a chronic relapsing brain disease. I didn't know that before. I didn't know that addiction does not discriminate. It's an equal opportunity disease. I didn't know that either. I thought that because Casey was raised in a two-parent family, because he didn't see drug misuse in our home, because he was intelligent, because he went to church and Sunday school, because for all of those reasons and more, I did not think that Casey would have a problem with addiction. The other thing I didn't know was that addiction is a treatable illness. So many times during the time that I was trying to get help for Casey, I was not given any hope that he could be better. In fact, it was even sad to say, people in the program that didn't hold out much hope for Casey. Because at that time, if you were addicted to heroin, I mean, they pretty much wrote you off. Now, thankfully, we have more options and things have changed in the last almost 13 years since Casey's been gone. The last time that I saw Casey skateboard on our driveway, he said, "They can't take this away from me, Mom." But they did. And the day that he was talking about was drugs. I know that the drugs took Casey's brain to start with. They took the spirit of who he was next, and then they took his life. And the drugs didn't stop until they took it all. As a retired teacher, I thought I could teach Casey out of using, out of drugs. I thought I can just get the big book out and I can tell him how it's what it says in the big book and what he's thinking and how that differs, and I could change his mind and I could fix it, because that's what moms do. I never thought that Casey would die from what I call a socially unacceptable disease. And even though we have made great strides as far as people understanding addiction better and having better treatment for addiction, we are still not there yet. There are still people who still believe that it is a socially unacceptable disease. It's one that you don't receive condolences or casseroles for like you do for other diseases. Even though I knew that Casey was a risk taker and that he had a genetic history that would predispose him to addiction, what I didn't know was about the affordability, accessibility, and availability of drugs in our community. After all, we lived in, and still do, live in southern Kenton County. Who would think that there would be drugs in that area of Kentucky? I had suspicions about something going on with Casey, but I never could put my finger on it. You know, it was like I had that gut feeling, as moms do. And a lot of times I will ask this question, and I'll ask it to you. Have you ever walked into a room, you've not said a word, you've looked at your mom, she looks at you, and she says, "What's the matter?" What do you suppose that is?
The mother's intuition.
Exactly. And you know, that's the thing that I didn't pay attention to, and I regret to this day. Because I was looking to the professionals, I was looking for people, I was looking for the counselors that knew more than I did, when in fact I knew better than anyone about Casey. And you know, as you can see, like I said, he had all kinds of interests, but as he got older, in middle school and into high school, all of those things started falling away. He forgot about, you know, riding his dirt bike and shooting pool and skateboarding and frisbee golf and playing his guitar and all the other interests that he had. He lost the ability to find joy in any of that. In high school, finally I decided, well, I don't know what's going on. I can't put my finger on this. Let's get a counselor. And so we took Casey to a private counselor, not a school counselor. And after a while, the counselor called us into a session and he said, "I think that Casey's the kind of kid that likes to walk on the edge, but I don't think he'll ever go over the edge." And I thought, well, that is a big relief. He's going to be okay. And I thought that because that counselor had certificates on the wall that said he knew things, that he had been trained and he could predict. Well, his prediction was faulty, and mine was even more so as I put my misplaced faith in that prediction, believing that he had any ability to predict the future and what that was going to hold for Casey. So by the time that we realized what was going on with Casey, he was well into his addiction and admitted it on his own and asked for help. And I thought, well, great, this is wonderful, because that's what they keep telling me he has to do. He has to want help. He has to ask for help. And so he did. Once he admitted that he had a problem, then I thought it was just a matter of, well, we'll take him to get some kind of medical help and treatment, and he'll be fine, because that's what I had done as he was growing up. When he was sick, I got help and he got better. And in all my 12-step meetings that I was going to, because I was taking myself to Al-Anon meetings and Nar-Anon meetings and trying to learn as much as I could and get as much support as I could to deal with our crisis, I was being told that addiction was a disease much like cancer and diabetes. And so I assumed that we could get help for Casey in the same way that you would get help for someone who had cancer or diabetes. I was wrong. And that became blatantly obvious when my husband was diagnosed with cancer. And I saw the difference in how he received treatment and how Casey didn't. Because when my husband was diagnosed with cancer, he was put into a clinical trial. He was told to go to the best hospital that the doctor knew of, which was Ohio State University. He got a stem cell transplant, and within a matter of 6 months, he was a new man. When Casey realized, and we realized, that he had the disease of addiction, we were told that he had to want to lose enough and hit bottom, and my doctor wished me good luck. I can tell you that none of those things was helpful to us. Certainly not helpful to Casey. The fact is that Casey did ask for help. One night he called and he said, "Mom, I'm in trouble, I need help." And I offered to come and get him that night, and he said, "No, Mom, I promise I'll be home in the morning." I said, "I'll come get you right now, Casey." "No, I promise, Mom." So not knowing when I went to bed that night whether he would show up the next morning or be able to show up the next morning or not, he did. And as soon as he hit the door, he said, "Where are we going, Mom?" Because he knew that I had been working towards that end. Even though I had faced all kinds of roadblocks and barriers, I had been working on trying to get help for Casey. And I said, "Casey, they won't let me make arrangements. You have to be the one to call." You know, I didn't understand then, and I don't understand now, how someone who has a brain disease is expected to make that kind of a decision. We don't expect people who have mental illness to be able to just wake up one day and decide they need help and make arrangements for themselves. They have advocates that help them do that. They have therapists that help them do that. But they expected Casey to do that on his own. So we took him to he did get a bed in a facility. In fact, the first call he made, though, is the facility that I now work for as a recovery advocate, and that facility is Transitions, Inc. It's a nonprofit charity that provides treatment for substance use disorders and related issues. And so he didn't find a bed there, and that's the problem now. People still aren't finding beds there because there is a grand total of, how many beds would you guess? In their detox unit. I'll be more specific, in their detox unit. 6?
14.
Well, somewhere in between. There's 11. 8 for men and 3 for women. You know, we have an epidemic going on, and we have a grand total of 11 detox beds. So they told Casey that he should call back the next day. What I say about that is that would be like telling a person who's having a heart attack, take 2 aspirin, call back in the morning if you're still living and breathing. So Casey went to another facility, and at that point he was told, well, we tried to do an intervention at that facility, and the professionals at that facility said, well, if he doesn't want to stay, there's not any point in it, and refused to do the intervention. And so Casey left after 6 days. After his second overdose, he had 1 overdose before that. The first overdose, he was put on life support, but he survived it. The second overdose, when he was taken to the hospital for that one, he was given the Narcan shot. When we got there, he was on a gurney, and the nurse was on the floor in front of him, telling him about the 2 A's in her life. And finally, out of exasperation, I think, and frustration, she looked up at me and she said, "Honey, he's still too young. He hasn't lost enough yet." And I looked at her and said, "What if he doesn't live to be old?" After the third overdose, he was no longer able to say, "I'm sorry, Dad, I'm sorry, Mom, I know I'm a big disappointment to you." He was in a coma. So he definitely, he wanted to, he definitely lost. And he lost enough. Before Casey died, he had pretty much sold everything that he had. He really had no material belongings. He told the people that he was living with that he was downsizing. So he lost enough. He wanted to, he lost enough, and he definitely hit bottom, because after that third and final overdose, we had to let him go after 10 days of being in a coma. And he is buried now at Spring Grove Cemetery. Casey died at the age of 23 on August the 19th of 2002. You know, I don't know that there's a mother alive that doesn't fall in love the first time that they see their child. And I know that I definitely fell in love with Casey that very first time. And I could envision what it was going to look like, how he was going to go to kindergarten, and he was going to go to elementary school and high school. We'd celebrate graduation. He'd go to college, get a good job, find someone he loved and cared about, get married, have children. I'd be a grandmother. I had it all planned out. But it didn't work that way. What I know now, though, is that Casey is in everything I do. He is my passion. He is the reason that I'm here tonight. A quote from Bishop T.J.D. Jakes says, "If you can't figure out your purpose, figure out your passion, for your passion will lead you right into your purpose." I know that was true for me, that my passion did lead me into my purpose. When Casey died, I didn't know how I was possibly going to go on. I couldn't imagine living life without Casey. I did not want to live. It was the first time in my life that I'd ever thought about suicide. I had never, that had never crossed my mind, never occurred to me to take my own life. But that certainly did when Casey died. It was a few months after his death, and I don't really know how many months, that I was able to make a phone call, because I can tell you that initially I was pretty much non-functional. I really could not function. Going to the grocery store was just a monumental task. First of all, I couldn't figure out if I wanted to eat, and if I wanted to eat, what I would eat. And then when I would go to the grocery, I would go up and down the aisles and out the door and have nothing. I just could not concentrate. I could not get it together. But after a while, I was able to. And so I made a phone call. And the phone call was actually to a place where Casey had been arrested. You know, we finally got to the point that we realized that the criminal justice system was the only way that we were going to be able to get any help for Casey. There was no way that we could get him any help, and our last-ditch effort would be to get him arrested. I had called the prosecuting attorney's office, and I had asked them about having Casey arrested, and they said, "Well, you can do that. Some parents do, but I just want you to know, if you do, you're out of the picture, and whatever the court decides, that's what will happen." And that scared me, because I did not want Casey to just be arrested and not get any help for his illness. And so I stopped short of doing that. However, right before Casey overdosed for the last time, he was in Noblesville, Indiana. And he was arrested with a small amount of pot and some paraphernalia. If he had gotten to his car, he had some Xanax under the floor mat that we found later. They took him to jail. He called home and said, "Mom, I'm in trouble. I need help. Big mistake." And I said, "Well, I'll talk to your dad and we'll decide what we're going to do. Knowing all along that we were not going to bail him out because this was our last hope. So we go up with two of our Nar-Anon friends, and I write out on a legal pad Casey's drug history as I knew it, because I wanted to present it to the judge that day and beg for help for Casey. So when we go into the courtroom, the bailiff comes out, and I ask her if I can give this to the judge and tell her what it's about, and she said, well, we're not here to deal with that today. He's going to be released on his own recognizance. I shook the paper at her and said, I'm trying to save my son's life. Didn't make any difference. She said, well, just take that down to the prosecuting attorney's office and they'll make a copy of it. I did, they did. I went back up to the courtroom. They released Casey that day on his own recognizance with the warning that he could receive a summons within 90 days to appear in court to face charges. Well, we did get that summons. It's a little tattered and torn now. I've carried it around now for almost 13 years. The problem was this summons came the day of Casey's funeral. He overdosed the third time right in August, and that day, on the 22nd of August, we received the summons for him to appear in court. Too late for Casey. So after, like I said, after a while, I was able to make a call. I called the court, and a lady answered the phone, and I said, I'm Charlotte Wethington. I'm calling in regard to Matthew Casey Wethington. I'd like to know the judge that he appeared before, because I wanted to write a letter to that judge, send a picture of Casey, and beg him to please, if he had the opportunity to intervene on someone else, to please do so. When I said that, she said, well, we have a warrant out for his arrest. I said, well, good luck. He's at Spring Grove Cemetery today. And I told her what I wanted to have happen that day, that I wanted the judge to order treatment for Casey. And she said, oh, well, you don't understand how the system works. Unfortunately, I knew all too well how the system didn't work. And I said to her, well, if that's how the system works, there's something wrong with the system. Now I had a purpose. You know, that's Casey's stone, and it says there is a light that never goes out. Casey liked the Smiths. I don't know if you all are familiar with the Smiths or not, and that's a line from one of their songs. There's a light that never goes out. And hopefully, because of Casey's life and death, other lights won't go out. And I am honored to be the bearer of Casey's light. There was no law, and then Casey died. From passion to purpose, Casey died and an advocate was born. I had no idea that that would be the purpose for my life. Before I said I had a profession, I was a teacher for 27 years. It was never in my plan to become an advocate. But thankfully, I now have a reason to go on living. I have a purpose. The greatest oak was once a little nut that held its ground. You're looking at the little nut. You're also looking at what might be referred to as the shirtless dancer. So we're going to watch a little bit of a YouTube video.
Sorry.
And please?
Sorry.
Okay, I was sending somebody on the hunt of you.
I like to call it Dr. Engel.
You'd like to?
I'd like to call him Dr. Engel.
Dr. Engel's. Well, actually, Dr. Engel was the first follower.
Oh, okay.
I was the lone nut.
You're the lone nut?
I'm the lone nut, and he's the first follower.
You've learned
Yeah. Yeah. Uh-huh. Yeah.
a lot about leadership and making a and let's watch a movement happen, start to finish, in under 3 minutes, and dissect some lessons. First, of course, a leader needs the guts to stand alone and look ridiculous. But what he's doing is so simple, it's almost instructional. This is key. You must be easy to follow. Now here comes the first follower with a crucial role. He publicly shows everyone else how to follow. Notice how the leader embraces him as an equal. So it's not about the leader anymore, it's about them, plural. Notice how he's calling to his friends to join in. So it takes guts to be a first follower. You stand out and you brave ridicule yourself. Being a first follower is an underappreciated form of leadership. The first follower transforms a lone nut into a leader. If the leader is the flint, the first follower is the spark that really makes the fire. Now here's the second follower. This is a turning point. It's proof the first has done well. Now it's not a lone nut and it's not two nuts. 3 is a crowd and a crowd is news. A movement must be public. Make sure outsiders see more than just the leader. Everyone needs to see the followers because new followers emulate followers, not the leader. Now here come 2 more people, then 3 more immediately. Now we've got momentum. This is the tipping point, and now we have a movement. As more people jump in, it's no longer risky. If they were on the fence before, there's no reason not to join in now. They won't stand out, they won't be ridiculed, and they will be part of the in crowd if they hurry. And over the next minute, you'll see the rest who prefer to stay part of the crowd, because eventually they'd be ridiculed for not joining. And ladies and gentlemen, that is how a movement is made. So let's recap what we've learned. If you are a version of the shirtless dancing guy, all alone, remember the importance of nurturing your first few followers as equals, making everything clearly about the movement, not you. Be public, be easy to follow. But the biggest lesson here, did you catch it? Leadership is over-glorified. Yes, it started with the shirtless guy, and he'll get all the credit, but you saw what really happened. It was the first follower that transformed a lone nut into a leader. There's no movement without the first follower. See, we're told that we all need to be leaders, but that would be really ineffective. The best way to make a movement, if you really care, is to courageously follow and show others how to follow. When you find a lone nut doing something great, have the guts to be the first person to stand up and join in.
Okay, so I was the shirtless dancer. I can tell you that I didn't have a movement going for a long time. In fact, it was about 10 years later that actually Dr. Engel was the flint that started everything. He got everything going and was the spark. And I am so, talk about being grateful, I am so grateful for him and what he was able to do. You know, but here's the thing, you know, I was that lone nut. I was doing something that was so against everything that anybody else was saying. You know, by this time I had also gotten involved, when I was trying to get the law passed, I was also involved with PAR, People Advocating Recovery. We'll maybe talk about that in a little bit later. But, you know, I had people that were looking at me like, involuntary treatment? Really? Is that really what you want to do? Are you trying to lock people up? You know, I was fighting those myths of you have to want to, lose enough, hit bottom. That was a rhetoric that was widely, and still is widely accepted. And I was going against all of that. And I wasn't anybody special. I was Casey's mom. That's it. That's all. Casey's mom. I had no PhD. I had no degree in addiction. I was just a mom. But I can tell you this, I was a mom on a mission. I was a mom on a mission. And you don't mess with moms. I said I was like a loose cannon shooting off in all directions, hoping that I would hit something. Not knowing if I would, but just hoping. So why Casey's Law? Why even try to get a Casey's Law passed? Well, I had heard from one of my Al-Anon friends about a law in Florida. It was called the Marchman Act. And that law provided an involuntary treatment act for families who lived in Florida. And so I thought, well, that could be translated and transferred to Kentucky. The other thing that I knew, and it didn't take me long to figure this one out, was that we were incarcerating hundreds of people thousands of people for having a disease. Not because they were criminals, but because they had engaged in criminal activity due to their addiction. So that if they had been treated for their addiction, they would have never ended up being incarcerated. And this is what I also knew, that jails were never intended or designed for treatment. That's not what they were created for. And I also knew that not only were we going through this kind of crisis, Casey wasn't the only one. I knew that there were other Caseys out there. I knew that there were other families just like ours that were going through those same things and had no help, that were desperately seeking a way to intervene on their loved one. So I went to my representative, my state representative, Tom Kerr, and I told him that there was another law like the one I wanted for Kentucky in the state of Florida, and that Kentucky would not be setting a precedent if this kind of law was adopted in Kentucky. And so he was willing to introduce the bill in 2003. It didn't pass. And then because it didn't pass in 2003, he was willing to go back again in 2004 and introduce it again. I can tell you that there were a lot of naysayers around. You know, there some that were very close to me, actually. I was told repeatedly that it would probably take 5 years for Casey's Law to pass. I was told that insurance companies would never allow it to happen. I was told all kinds of negative things. You know, that's something about an advocate. An advocate has to be willing to step up, speak out about things that may be very unpopular, and they have to be willing to take a risk. You know, it really shouldn't surprise me that Casey was a risk taker, because I guess I am too. I was willing to risk putting myself out there, putting Casey's story out there, making myself vulnerable. Very vulnerable. In fact, you know, I didn't even think about that aspect until someone came up to me one day and they said, "Charlotte, you make yourself very vulnerable." But I was willing to do that because I saw that how this could possibly make a difference for other people. And so when I went to Frankfurt, I went with one thing and one thing only. I went with Casey and his story. I didn't have data. I didn't have any kind of big studies that proved that this could work. I had no evidence that this would be beneficial. I only went with what I knew, and what I knew was about Casey. I knew our story. And you know, it was one of the people in PAR that said to me, "You know, Charlotte, you're the expert. You're the expert on your story, because nobody knows your story as well as you do." And so that's what I went to Frankfurt with. I want to show a video, but it's going to be about a 45-minute video. So we might want to take a break now, maybe get up and stretch a little bit, maybe get a drink or whatever. And then when we come back, I want to show you the video of when Casey's Law came on the House floor. And what I want you to pay attention to as you're watching it is how advocacy was going on the House floor. How there were legislators who stood up and advocated for Casey's Law. And I also want you to notice the demonstrations of the stigma and the repeated how the myths that we talked about earlier were repeated as people were discussing this on the House floor. So we'll take a break. Now, let me preface, before we start this, let me say one thing. This gentleman right here is Representative Steve Nunn. I thought that when I filed the law the first time, or when it was filed in 2003, the chair of the committee would not hear it, and so it died in committee. And so the second time when we went back, it wasn't assigned to the same committee, it was assigned to a different committee, and the chair would not call it up. So in order to get it moved through the House and ultimately the Senate, because it had to go through both of those, we found a vehicle to do that, and that was to attach our language on this representative's bill. And so what had happened was his bill went to the Senate and passed unanimously with our language on it, the language for Casey's Law. And so now he's bringing it back to the House floor and saying that he wants to pass it with that language on there, but he's been asked not to, because there's been some advocating going on the floor there, and then some finagling and all of that going on the House floor. And if you've never been to watch a legislative session, it's a real education, because they're just like a bunch of bees that are just kind of buzzing around, and they're making all kinds of, well, I will say deals on the floor as they are talking with each other. So he's been pressured into saying that he is recommending that they not accept the bill as amended. So we'll start it.
Made a big difference on
House
those
Bill
26 pages. Made a
67
big
is
thing about
adopted.
it.
Gentleman from Barron.
For that diehard, I move that the vote by which House Bill 67 passed for the Senate floor amendment be reconsidered and that motion be laid upon the table.
Pretty good. Without objection.
Well, what a night. That was what a night. And you know, the gentleman from Henderson actually was standing over close to me, and he had suspenders on that night, and he put his thumbs in his suspenders and said, well, I did the right thing. I can't imagine how many more people probably would not be alive today, and certainly not living in recovery today, if that bill had not passed in 2004. You know, you heard how the representatives were talking about how bad it was in their districts. Can you imagine what they would say today? You know, that was in 2004. That was 11 years ago. I know that things are so much worse now than they were then. And so I am so very grateful for the advocacy that took place on the floor that night. But I'd be interested in hearing what really jumped out at you. Were there things in the proceedings that really spoke to you about what was said, some of the comments? Yes.
Something that was surprising to me was how disinterested so many of the people in that room looked. Like they just didn't, they were talking to other people, they weren't listening, and like, I get it, because I'm in a sorority and we have meetings where it like runs for hours and hours and we're voting and voting and voting, and I get disinterested too, but on something that important,
Right.
and like those are our, those are our state's leaders, those are important leaders, and it was kind of disheartening to see that, because it's like, obviously they don't care that much. So, I don't know, because I feel like this happens too in our chapter, where I feel like sometimes things pass just because they don't feel like being there any longer, so like fine, like just push it through, we're done.
Right.
So.
Well, I think you may get a little bit of a different perspective come Thursday night. So I think your faith may be restored a little bit. But you know what? Again, what I was doing was so foreign to everybody. They just they weren't prepared for anything like that. Even though, as my representative said, You know, this was just an extension of the 202A, which is the mental health inquest. So it really wasn't all that foreign, but, and then the issue too of the money, you know, the money was the big issue. In fact, the lady that stood up and said, you know, it's the 58th day and the 7:30 at night, she said to me after a committee meeting one day that I was discriminating, and that I was making it so that people could not file the petition. It would only be people with money that could do that. And I said, that's not my intention, is to discriminate, certainly not. However, I wanted to get a tool in the hands of people so that if they could find treatment at an affordable price, that they could actually take advantage of it. And fortunately, right after Casey's Law passed in 2004, in 2005, Governor Ernie Fletcher created the Recovery Kentucky Initiative, which created 10 recovery centers, 2 in each congressional district, 1 for men and 1 for women, at no cost. At no cost. That opened up 1,000 beds in Kentucky for men and women, so that actually people have been able to use Casey's Law even if they did not have a penny. So that, you know, that was such a godsend, really, to have that available. I saw a hand over here, I think, first. Did you have your hand up? No? Okay, you had your hand up.
No, I was just kind of, I mean, I can understand when I was looking, you know, watching this, you know, other people are discussing and they might be collaborating with each other on it and stuff, but I also feel the same way. To some extent, I thought it was disrespectful. And the other thing that, I don't know, with hearing, I mean, I could understand some of that woman's concerns, but, you know, it kind of made me mad listening to her, because, you know, she's like, here we are on the da-da-da-da, and it's like, okay, yeah, here we are on the 40th whatever day, and how many people are overdosing and dead right now? You know, the clock is ticking. And so what makes me really mad about this, and this is one thing, because I'm going to be specializing in addictions. And one of the things that makes me so angry, and I did research on recidivism and about one of the reasons why I am wanting to do jail ministry, you know, because a lot of our jails, one of the biggest problems with our jails is there are people in jail that should not be in jail. Our jails are being overcrowded, you know, by addictions. These people who did not, you know, like they were saying, people who did not. In the state of Kentucky, the Louisville prison alone is one of the most, it spends more money than any prison in the United States. If they were to take some of that money that they're spending on these inmates and get these inmates and take that money and put it, open up centers and have these addictions, people who, and transfer them over to these centers, it would be so different. And instead, these people are getting these things on their records and they can't go out into the public, they can't find work because they have these felony convictions. And this affects our community.
Absolutely.
So I just get angry, and this is a really, you talk about passion, I have passion for this. And I'm gonna fight, in my future, I see fighting every tooth and nail to get whatever it takes, whatever, if I have to, right, like I said, a grant money or whatever I have to do to get a center or something, or get these people out of jail that shouldn't be in jail, I'll do it. And just listening to this makes me even more angry when I hear some of that. But I was happy for the end result.
That's good, you're fired up
Oh,
now.
I'm very fired up, very fired up.
Yes.
Something I wondered about this law, like the petitioner is the one who, you know, has to pay and they choose the facility. If the person who is addicted, say that they, you know, they realize they, you know, say that, you know, I do have a problem, I am open to treatment, but they don't want to go to the treatment center that the petitioner picked, is there any, like, do they get any say? Because I know a lot of the people on there were saying that, you know, they're incapacitated, they can't make
Right.
their own decisions, because
Well, I have mixed feelings about that. I mean, there was just an instance today that I was involved in where, according to the mom, the person was wanting to make the choices. You know, he didn't want to go here, he didn't want to go there. This is the way I feel about it. If you're the petitioner and you have the right to choose the facility, and you may be paying for the facility, then you're going to choose the facility. And that's going to be dictated in large part too by the evaluators. We're going to go through the steps in just a minute. So, but I think, did you have a question? I saw hands over.
No, but you go ahead.
Well, first of all, in answer to your question, what stood out to me was even in the floor debate about the amendment, a lot of the comments were based upon the stereotypes and the stigmas.
Right.
One legislature referred to it as dope. And just how reliant they were upon stigma and the legislative tricks.
Well, and did you catch the part about the wanting to? You know, and infringing upon people's liberties. So afraid that we were going to take their liberties away from them. We don't think a thing about taking liberties away when we lock them up in jail or prison. Not a thing. But all of a sudden, when we're trying to get help for people, then we're worried about their liberties. And then with the gentleman from Henderson talking about, well, if it's a friend, if you have something against somebody and you just want to have them locked up, or you're going to file a petition against them. As we go through the process, I think you'll find that this is not a walk in the park. It does take some effort on the part of the petitioner. And plus that guarantee of payment at the end, I would think would be a deterrent for someone who is just trying to punish someone. But you know, that's laughable for me, because I can't think of a better gift that you could give somebody than to get them into a treatment program with the hope that they're going to recover. I mean, that's a gift. That is a gift. So, you know, to act like that's a punishment, I think is just tragically funny. Yes.
Oh, well, I'll see you one and raise you one.
Okay, go ahead.
Your comment, or your response is tragically funny. My response would be tragically immoral. They're willing to spend money on things like jails, which cost millions of dollars, but they're not willing to spend hardly anything in comparison on treatment. Where if they did spend something on treatment, they wouldn't have to spend so much on jails.
Absolutely.
Amen.
Absolutely. For every dollar spent on treatment, there's at least a $4 return just in criminal cost alone. That doesn't take into consideration healthcare cost, loss of productivity, other factors, and I think it ends up being what, Jason, up to about $11 or something? You know, where can you invest $1 today and get $11 return on that dollar? I don't know of anywhere. I had another thought, and I've already lost it, Ron, but when you were talking about the jails, and but you know, jails are big business. Jails are big business, and I want to give you a quote though that I heard from a person who's a director of a program over in Cincinnati. When I heard him speak the first time, I knew I liked the man, because he said, "I hope to live to see the day when addicts and alcoholics are raised to the level of the aluminum can." I'm going to say that again. I hope to live to see the day when addicts and alcoholics are raised to the level of the aluminum can. Now, I don't know if it struck you the way it struck me, but we are willing to recycle and recycle and recycle and recycle inanimate objects, but we're not willing to invest in human beings.
I gotta think part of the reason for that is because, and I'm going to get blatantly political here.
Okay.
A lot of politicians are hung up basically on two sins. And they will do anything about these two sins that the Supreme Court has said we really can't do anything about. But they're ignoring the thousands of sins that we can do something about. They're ignoring the sins that relate to drug addiction. They're ignoring the sins that relate to alcoholism. And those are sins that we can do something about. But they're so hung up on the two that we can't, that they're ignoring the thousands that we can. And with some better choices about how we spend our money, we're going to spend it one way or the other.
That's right.
We're going to spend it on treatment, or we're going to spend it on jails.
Right.
And where do we get the best bang for the buck?
Right.
And it's immoral to do anything but.
The problem is that advocates, lobbyists have been hired to go to Washington and create environments that require the United States to lock up so many people. We have contract, we've privatized the prison industrial complex, and now the United States is fiscally obligated to lock up so many people per year, or the government will get sued. They'll get sued by these companies that own the prisons. So if we,
That's a sad state of affairs.
it is a sad state of affairs.
Very
So
sad.
if that's where advocacy comes in,
Yes.
if we need that same power in DC, we need that same power in Frankfurt, we need that same power locally here on the streets, in the communities, in the nation, in the capital.
That's right. Yes.
Well, and something that I noticed too is that, and something I've just noticed
And within 2 weeks, they had arrested him. And he had to go to trial and so forth. Then he was mandated to get treatment. Had I not done that, I think my son would be dead today. But he's turned out to be a pretty good kid now. He's past 40 years old. I guess if you get him past 25, they'll all make it. But he's got a family, got his own home, and he's a very responsible job. But I say that he had not had his intervention, I don't believe he'd be alive today. And I urge you to adopt this amendment, Mr. Speaker.
He was the chairperson that would not hear it the first year.
64.
He ended up speaking for it the second
The
year.
motion.
Speaker, ladies and gentlemen, I just wanted to take this opportunity to talk about this amendment because I've been working on this issue for a couple of years, for a couple of sessions now. And I want to say that this is not a totally new concept in the law. It's simply just an extension of a process that we already have for mentally ill persons. We just took the language that we have currently for mentally ill persons and extended it to persons who are substance addicted. Now, the argument is there, if someone is addicted to a substance, whether that be alcohol or drugs, they can no longer control themselves. They can no longer make decisions about what is best for them. The bill has several protections. First of all, it says that the person can be committed for involuntary treatment only if they're a danger to themselves or others. Same language that we use for mental illness. Also, it provides that that person is entitled to due process procedures. They have to go through a hearing, have a court-appointed attorney, and so on. So all the procedures, all the safeguards are there. Someone has said that, well, involuntary treatment is not any good, that only voluntary treatment works. But I would submit to you that most of the treatment for substance abuse in our state is involuntary. But here's what happens. Normally, it has to get so bad, as the gentleman from Jefferson said, that the person is charged with a crime. Once they're charged with a crime, they appear in front of the court, and then they're sentenced as part of any probation or leniency. They have to go to that drug treatment program. So they're there. They're not there voluntarily. They're there involuntarily. So it's the same procedure, except here we're saying that the family can petition the court and have this done without having to wait till a person's charged with a felony until it gets that bad. This law is modeled after the Florida law. Missouri has the same law. It's not completely innovative. We're just doing what some other states are already doing. The one important point that we need to remember here is that these folks who are in this condition no longer able to make the decision for themselves. A family member has to step in here. And where we have in the law that it can be a family member or a friend, that's in the current law for mental illness. It's already in the law. It's nothing new. As far as the cost goes, we have drafted this bill to say that if you want to seek help for your family member, you have to agree that you're going to pay for the treatment. Now, that means a lot of people won't be able to use this. A lot of people won't be able to take advantage of it. But the fact of the matter is, we don't have money in the Medicaid budget right now to make it available to everyone. In the future, if there's money available where the state can pay for this treatment, great. We'll address that at this time. But right now, we're just trying to get the concept in place. If the family member wants to avail themselves of this mechanism, all they have to do is say, yes, I'll pay for the treatment. That's part of signing the petition. That's in there. So it's not going to cost the state anything. It doesn't affect the budget. That's why you don't see any budget note attached to this. I would like to suggest to you also that this affects a great number of Kentuckians. Statistics show that 7 out of 10 families in our country are affected at some time or another by substance abuse. I'd like to take this moment just to introduce someone here who certainly is my personal page today, Charlotte Wethington. I don't think she'll mind if I mention her. This bill is named the Matthew Casey Wethington Act. If you look at the language, you'll see that it's named for him. Charlotte here is Casey's mother, and she never had the opportunity to present her story in any committee here, but I'd like to take a moment just to tell her story. Her son Casey became addicted to heroin at a young age, but because he was an adult, over 18, she could do nothing about it. In February of 2002, he finally got to the point where he said, I want treatment. He went in just long enough for detox, and then he was out, just like the gentleman from Jefferson mentioned about his family member. Nothing could be done by the family. In May of 2002, he was taken to the hospital because he had overdosed, but the hospital said, we can't keep him because he didn't intentionally try to commit suicide, so they had to release him. In June of 2002, he overdosed again. This time, he was released once more, again, because they couldn't hold him. Finally, on August 9, 2002, he overdosed a final time. He entered a coma from which he never emerged, and 10 days later, he left this earth. Excuse me. Ladies and gentlemen, we have an opportunity today to do something with this bill that will help our families in Kentucky who are afflicted with this problem, and there's more of them every day. I would ask you to vote against the motion, and we then entertain a motion to agree with the Senate. Thank you.
The gentleman from Oldham, 59, for discussion on the motion.
Thank you, Mr. Speaker. I also rise in favor of concurrence with this amendment. It was mentioned earlier that this is a 26-page amendment. However, at least half, if not more, of the amendment is used up in showing and changing references to different cabinets and all that. The heart of this amendment, which we reviewed here, gives the protection rights that are needed for a court review. And as the gentleman from Kenton pointed out, the cost would be borne by the petitioner here. I feel that there's no risk to the state to do this. I think it addresses an important problem. And this late in the session, we run the risk of this not being addressed for 2 years. So I would urge the body to concur in this Senate amendment. Thank you.
I recognize this gentleman from Ballard 1 for discussion on the motion.
Thank you, Mr. Speaker, ladies and gentlemen. I've been here a good while, and it's one of the few times, if ever, that I remember when the sponsor of a piece of legislation requests that we do not concur in a Senate amendment or a Senate committee substitute, and then there's a debate on whether or not we should concur. Generally, if the sponsor's not happy with it, then we go along with the sponsor. That being point number one. Point number two, I would concur with the gentleman from Henderson that we've got a 26-page amendment. If this 26 pages were a bill before the House Judiciary Committee, you could bet that it would have been reviewed and reviewed again, and we would all be sure that the rights of these individuals would have been protected. I don't know that. Very seldom do you see a 26-page floor amendment. That means it has not gone through the committee process, has not been reviewed, and we can't be sure that the rights of these individuals have been protected. I don't see anything wrong with not concurring. Let this go to conference committee. We'll be back here on the 12th and 13th, and that will give people an opportunity to digest the bill, go through it line by line, and I'd feel much more comfortable voting for the bill after it goes to a conference committee, and we can be assured that the people, the rights of these individuals are protected. So I would urge that we do not concur.
I recognize this gentleman from Union 7 for discussion on the motion.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I know many members in here have had personal experiences with situations such as drug abuse. When you have someone that's very close to you and almost like a family member that gets hooked on some of this stuff, you feel compelled to do something, but without a proper law to do that outside the family, you can't do it. This would help that along, but on the same token, with an amendment that's 26 pages to it, there may be some things in there that are not so good, such as maybe I've got a neighbor across the street's got some unruly children, may not even be hooked on dope. Well, I don't think we'd want to be able to have my kids or the next door neighbor's kids committed for treatment because they're unruly. So I think we need, as the gentleman from Woodford particularly and the gentleman from Henderson that made the statement, that it needs further study, and the gentleman from Ballard here also indicated it needs, I think it does. I think it needs further study, but I also like the fact that if you know somebody's hooked, but they're capable of convincing their parents that they're not, then I think there is an issue here that really needs to be looked at. So as the gentleman that's sponsoring this said, let's don't concur, let's read it, study it, and maybe we can get something done in conference. Thank you, Mr. Speaker, ladies and gentlemen.
Gentleman from Russell 83, you recognized for discussion on the motion, sir.
Thank you, Mr. Speaker, ladies and gentlemen. In my law practice, I do a lot of practice in district court of misdemeanor offenses, a lot of marijuana possession, a lot of DUI cases. I also do some in juvenile, and I primarily do criminal defense. And I see so many times, week after week after week, people that want help, family members that want to give members of their family some help, but there's no way to do that under the current law. And so many times family members go to the county attorney thinking that the county attorney can help them because of the protections that we have for people with mental illness. They think we can do the same thing, but we cannot. I think this language, while it has not been reviewed, gentlemen from Ballard, I don't think we've got time to review it. The language is there. It passed the Senate. I think if we don't act today, someone, or maybe many people in the next year, could have an opportunity to use this law to get some help. And if we don't act today, they won't have that opportunity. I can tell you in rural Kentucky, there are family after family after family that would love to have this provision in the law that they can get family members some help. So with all due respect, I would urge us to vote no on the gentleman's motion, and let's concur in what the Senate has done. If it needs to be looked at in January to make some revisions, we can do that. but let's don't deny all of those people who are out there, family members, who want to get family members help. Let's don't deny them that opportunity. Thank you.
Chair recognizes the gentleman from Harrison, 78, for discussion on the motion.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I'm not going to suggest how you vote on this, but I do want to say a word about the seriousness of what we're talking about, and whether it goes to conference or whether we're able to deal with it today. It's something that has been certainly bothering me for at least 2 years since I've known of some of these situations. And I just urge us to seriously consider it, seriously think about it, and let's don't let this issue die. If it goes to conference, gentleman from Barron, I sure hope you can solve the problems if they're there and bring them back. And it's just something that I feel like it is so important and so important to the people of the Commonwealth. So I just want to bring to the attention of the body how serious this matter really is.
Chair recognizes the lady from Jefferson 34 for discussion on the motion.
Thank you, Mr. Speaker. Ladies and gentlemen, I too want to urge that we send this to conference committee. How many of us have read this? This is a 26-page amendment. As serving as the chair of the House Bill 843 Commission for 4.5 years with the gentleman from Whitley, the gentleman from Jessamine, 3 senators, we're struggling with these very issues. This is a huge policy change that we have looked at in the House Bill 843 Commission. There's consumers, there's family members, there's law enforcement involved. But to put a 26-page amendment on the 58th day of the session at 7:30 at night and to ask members to vote on this when it can affect thousands of Kentuckians, it's a terrible problem. It is a terrible problem, ladies and gentlemen of the House. But I think that it needs to be looked at. I agree with the gentleman from Henderson. The House has not had any input into this amendment whatsoever. And as I said, on House Bill 843 Commission, which is involving thousands and thousands of your constituents across the state in regional planning councils, and they are wrestling with these issues, and they're bringing these recommendations from the grassroots up to the Commission of 843, which you all have all heard of and has gained a respect in this Commonwealth, to deal with issues of substance abuse, of mental health, of how do we fund it. There's a huge hole. The gentleman from Kitten is exactly right. There's a huge hole in funding. If you have Medicaid or you have no insurance, this isn't going to help you. We've got to start looking at how we're going to pay for that. But I think to vote at 7:30 at night on the 58th or 59th day of the session on a policy issue of a 26-page amendment that came from the Senate is irresponsible. And I'd like to ask the gentleman from Barron to not concur. Let's take it to conference committee, work it out, get our foot in the door, and see how we can help these folks. Thank you.
Gentleman from Barron.
Thank you, Mr. Speaker. We've spent a great deal of time tonight. I would point out, though, to the lady from Jefferson and anybody else that thinks this 26-page bill is too long and too complicated for us, how many times are we going to vote on a budget at 11:30 at night on the last day, and it'll be 800 pages. So this is a rather simple issue to digest, and we will be able to act and do something that is so badly needed in this state. This bill passed the Senate 33-0. It got 33 votes out of 38 in the Senate. It's nonpartisan issue. This is about families and lives of people we love. And I would ask the clerk to report Senate Floor Amendment 1. It is reported. Okay, then I have to make the motion that I'm reluctant to make, but I would move that we do not concur with Senate Floor Amendment 1.
Okay. We're going to have a roll call, but there's some other people who want to be heard on this issue. Chair recognizes the gentleman from Hopkins 10 for discussion on the motion.
Well, the gentleman Barron, I yield a question.
Gentleman from Barron, will you yield to a question?
Somebody get me a water.
Gentleman from Hopkins.
If a person was turned in and they had to go through this process and they were committed 72 hours and got out, how long before someone, that same family, could have them be reevaluated and go through the same process? If they were unhappy with them, could they request that, have them to go through that thing, all that reevaluation again?
Gentleman from Barron.
As I understand the bill, they would have to re-petition the court. The court would have to reevaluate the circumstances related to the respondent as to whether that person had fulfilled their responsibility. If it's a 72-hour involuntary hold, as far as I know, the person that petitioned the court who agreed to bear the cost of that capacitation would be responsible for coming back again unless another family member or a friend were asked to do so. I hope that answers your question.
There's no time limit, excuse me.
Gentleman from Barron, Hopkins.
There isn't any time limit when that could be
Gentleman from
done.
Barron.
Not on a prohibition of repetitioning the court, no.
Thank you, Mr. Speaker.
Chair recognizes the gentleman from Morgan 71 for discussion on the motion.
Thank you, Mr. Speaker, and ladies and gentlemen of the House. You know, sometimes you have constituents that call you and they've got real problems. Real problems is having a mentally ill child who you can't get treatment for. A real problem is, you know, a child who's got drug problems and you can't get treatment for that child. And until you've looked in those parents' eyes and you've seen their pain and know they can't get help, that's a problem. Sure, it's late. This is the 58th, 59th day, and this is a complicated issue. But if we can't do it today, when are we going to do it? We're going to say next year that we can't do it on the 49th day, or if it's a 15-page bill. This is about helping people, just as the gentleman from Russell's said. I can't add anything but what's been said here, but these are real problems for real Kentuckians. And this is the first opportunity we've had to address those problems. And I applaud the gentleman from Barron to bring this issue forward. These people are crying out for help. This is not a perfect solution, but it is a solution. I just beg each one of you to give this a chance. We'll be back here in a few months and they'll have a few wrinkles that needs to iron out. But this is something that is so needed. These people need help and they have no recourse. They have no place to turn. Please, let's help these families. Thank you all.
Chair recognizes the lady from Carter 96 for discussion on the motion.
Will the gentleman yield to a question?
Gentleman from Barron.
Yes.
He will yield. Lady from Carter.
I embrace the concept of this bill. Nobody's lost any more clients than I have the last few years to this problem and this situation. However, I am a little concerned. I'm reading on page 15. I made it that far. Can a school bring a petition for a child?
Gentleman from Barron.
That is correct. In section 4, beyond the control of school means a child who has been found by the court to have repeatedly violated the lawful regulations of the school as provided in KRS 158-150 and documented in writing by the school as part of the school's petition or as an attachment to the school's petition.
Lady from Carter.
Will the gentleman yield to one more question?
He will yield another question. Lady from Carter.
And in the case where a school would bring a petition against a child and that child was committed for a period of treatment, who would pay for that?
Gentleman from Barron.
If the school was the petitioner, they would pay for the treatment.
Thank you. Thank you, Mr. Speaker.
Thank you, lady. Gentleman from Jefferson 42. I guess you don't want to do it. All right. Now, the motion is, seeing no other people to speak, gentlemen from Barron, you have anything else to wind up on, sir?
Just a point of information, a vote to not concur would be a yes vote. A vote to concur would be a no vote.
A vote to not concur, that's the motion, that we do not concur, so that would be a yes vote, that'd be a green. Those that do not, that do want to concur or don't agree with that motion will vote red. And
It got
several members
complicated.
have asked for
The
a roll
no vote
call.
was actually a good vote.
So, all members who wish not to concur, vote green. Those who do wish to concur, vote, or if you don't like that, vote red.
It took 3 votes. This was the first one.
Does any member wish to change or explain his or her vote? Gentleman from Whitley, do you want to explain your vote? Okay. Gentleman from...
Mr. Speaker.
Gentleman from
Mr. Speaker.
Where is Mr. Speaker? You do want to change it?
I want to explain my vote.
Okay. Yes, sir.
It was my understanding that if we non-concur, that it will go into conference, and there's all the time in the world, as far as I'm concerned, to work it out in conference and still pass it in this session. If something can be worked out to make this bill better, I think we ought to try. I certainly am in sympathy with those families and those people who want treatment, but you don't want to have it go bad just because we've not met the appropriate legal requirements. That's the purpose of my green vote.
Jefferson 43, you're recognized for explanation of your vote not to exceed 3 minutes, sir.
Mr. Speaker, I voted not concur because in my experience with this issue, in certain ways, a lot of people who have substance use problems also have mental health problems. There's a high correlation between the two, and therefore they are incapacitated both mentally and in many ways physically, and therefore the protections that are in the bill as regards to a person who's incapacitated would apply, I think, equally to a person who is suffering from substance abuse. This is necessary. This is a crisis right now in all our districts, east, west, north, south, urban, or rural. And therefore, we cannot wait, we cannot work, we cannot take the risk of coming back in 10 days. We need to pass this now. And I'm glad to see those 61 red lights up there.
Have all members voted? Clerk will take the roll. There being 32 members voting aye, 61 members voting nay, the House does not concur. Gentleman from Barron.
Now, Mr. Speaker, I'd like to move. We do concur.
No.
As I said, it got complicated.
No, you don't. You just did, that motion did not pass. Now, if you want to concur, you got to vote again. And if you want to make that motion, gentleman from Barron, you recognize so to do.
Mr. Speaker, I'd like to see us pass this bill with the floor amendment on it, but I said that I would not move to pass, to concur. So
Well, I think there's some others that probably will. Gentleman from Jefferson 35, what purpose do you arise, sir?
Mr. Speaker, I'd like to move that we concur with Senate Floor Amendment number 1.
Got a motion and a second that we do now concur in Senate Floor Amendment 1.
That's all we got up here.
Now, gentleman from Jefferson 35, do you want to speak on that or turn your light on? Okay.
I'd appreciate it, man.
All right. I don't see anybody else who wants to be recognized. So now the question is, if you want to concur, vote green. If you don't want to concur, vote red. And the roll call machine is now open for your vote. Have all members voted? Does any member want to change or explain his or her vote? Clerk will take the roll. There being 76 members voting aye, 17 members voting nay, something funny happened on the way to non-concurrence. Gentleman from Barron.
Mr. Speaker, a big thank you to all the families in Kentucky who may be positively affected by this. I move passage of House Bill 67 as amended in the Senate and concurred in by the House.
Motion now is for the passage of House Bill 67 as amended in the Senate and concurred in by the House. Is there further discussion? Seeing none, are you ready for the vote? Clerk, sound the chimes. Question now is on the adoption of House Bill 67. All members in favor vote aye. Those opposed, nay, and the roll call machine is open for your vote. Does any member wish to change or explain his or her vote? Have all members voted? Clerk will take the roll.
Guess who the one vote was?
One diehard voting nay.
About made a big difference about
House
those
Bill
26 pages.
67 is adopted. Gentleman from Barron.
For that diehard, I move that the vote by which House Bill 67 passed the Senate floor amendment be reconsidered and that motion be laid upon the table.
Pretty good. Without objection.
Well, what a night. That was what a night. And you know, the gentleman from Henderson actually was standing over close to me, and he had suspenders on that night, and he put his thumbs in his suspenders and said, "Well, I did the right thing." I can't imagine how many more people probably would not be alive today, and certainly not living in recovery today, if that bill had not passed in 2004. You know, you heard how the representatives were talking about how bad it was in their districts. Can you imagine what they would say today? You know, that was in 2004. That was 11 years ago. I know that things are so much worse now than they were then. And so I am so very grateful for the advocacy that took place on the floor that night. But I'd be interested in hearing what really jumped out at you. Were there things in the proceedings that really spoke to you about what was said, some of the comments? Yes?
Something that was surprising to me was how disinterested so many of the people in that room looked. Like they just didn't, they were talking to other people, they weren't listening, and like, I get it, because I'm in a sorority and we have meetings where it like runs for hours and hours and we're voting and voting and voting, and I get disinterested too, but on something that important.
Right.
And like those are our, those are our state's leaders, those are important leaders, and it was kind of disheartening to see that, because it's like, obviously they don't care that much. So, I don't know. Because I feel like this happens too in our chapter, where I feel like sometimes things pass just because they don't feel like being there any longer, so like fine. Like just push it through, we're done.
Right.
So.
Well, I think you may get a little bit of a different perspective come Thursday night. So I think your faith may be restored a little bit. But you know what? Again, what I was doing was so foreign to everybody. They just they weren't prepared for anything like that. Even though, as my representative said, this was just an extension of the 202A, which is the mental health inquest. So it really wasn't all that foreign, but, and then the issue too of the money, the money was the big issue. In fact, the lady that stood up and said, it's the 58th day and the 7:30 at night, she said to me after a committee meeting one day that I was discriminating. And that I was making it so that people could not file the petition. It would only be people with money that could do that. And I said, that's not my intention, is to discriminate, certainly not. However, I wanted to get a tool in the hands of people so that if they could find treatment at an affordable price, that they could actually take advantage of it. And fortunately, right after Casey's Law passed in 2004, in 2005, Governor Ernie Fletcher created the Recovery Kentucky Initiative, which created 10 recovery centers, 2 in each congressional district, 1 for men and 1 for women, at no cost. At no cost. That opened up 1,000 beds in Kentucky for men and women, so that actually people have been able to use Casey's Law even if they did not have a penny. So that, you know, that was such a godsend, really, to have that available. I saw a hand over here, I think, first. Did you have your hand up? No? Okay. You had your hand up.
No, I was just kind of, I mean, I can understand when I was looking, you know, watching this, you know, other people are discussing and they might be collaborating with each other on it and stuff. But I also feel the same way. To some extent, I thought it was disrespectful. And the other thing that, I don't know, with hearing, I mean, I could understand some of that woman's concerns, but, you know, it kind of made me mad listening to her, because, you know, she's like, here we are on the da-da-da-da, and it's like, okay, yeah, here we are on the 40th whatever day, and how many people are overdosing and dead right now? Mm-hmm. You know, the clock is ticking.
Right.
And so what makes me really mad about this, and this is one thing, because I'm going to be specializing in addictions.
Good.
And one of the things that makes me so angry, and I did research on recidivism and about one of the reasons why I am wanting to do jail ministry, you know, because a lot of our jails, one of the biggest problems with our jails is there are people in jail that should not be in jail. Our jails are being overcrowded, you know, by addictions. These people who did not, you know, like they were saying, people who did not, in the state of Kentucky, the Louisville prison alone is one of the most, it spends more money than any prison in the United States. If they were to take some of that money that they're spending on these inmates and get these inmates and take that money and put it, open up centers and have these addictions, people who, and transfer them over to these centers, it would be so different. And instead, these people are getting these things on their records and they can't go out into the public, they can't find work because they have these felony convictions. And this affects our community.
Absolutely.
So I just get angry. And this is a really, you talk about passion. I have passion for this. And I'm going to fight, in my future, I see fighting every tooth and nail to get whatever it takes, whatever, if I have to, right, like I said, a grant money or whatever I have to do to get a center or something, or get these people out of jail that shouldn't be in jail, I'll do it. And just listening to this makes me even more angry when I hear some of that. But I was happy for the end result.
That's good, you're fired up.
Oh, I'm very fired up, very fired up.
Yes.
Something I wondered about this law, like the petitioner is the one who, you know, has to pay and they choose the facility. If the person who is addicted, say that they, you know, they realize they you know, say that, you know, I do have a problem, I am open to treatment, but they don't want to go to the treatment center that the petitioner picked, is there any, like, do they get any say? Because I know a lot of the people on there were saying that, you know, they're incapacitated, they can't make their own decisions, because.
Well, I have mixed feelings about that. I mean, there was just an instance today that I was involved in where, according to the mom, the person was wanting to make the choices. You know, he didn't want to go here, he didn't want to go there. This is the way I feel about it. If you're the petitioner and you have the right to choose the facility and you may be paying for the facility, then you're going to choose the facility. And that's going to be dictated in large part, too, by the evaluators. We're going to go through the steps in just a minute. So, but I think, did you have a question? I saw hands over.
I have another one, but you go ahead.
Well, first of all, in answer to your question, what stood out to me was even in the floor debate about the amendment, a lot of the comments were based upon the stereotypes and the stigmas.
Right.
One legislature referred to it as dope. And just how reliant they were upon stigma and the legislative tricks.
Well, and did you catch the part about the wanting to? You know, and infringing upon people's liberties. So afraid that we were going to take their liberties away from them. We don't think a thing about taking liberties away when we lock them up in jail or prison. Not a thing. But all of a sudden, when we're trying to get help for people, then we're worried about their liberties. And then with the gentleman from Henderson talking about, well, if it's a friend, if you have something against somebody and you just want to have them locked up, or you're going to file a petition against them. As we go through the process, I think you'll find that this is not a walk in the park. It does take some effort on the part of the petitioner. And plus that guarantee of payment at the end, I would think would be a deterrent for someone who is just trying to punish someone. But you know, that's laughable for me because I can't think of a better gift that you could give somebody than to get them into a treatment program with the hope that they're going to recover. I mean, that's a gift. That is a gift. So, you know, to act like that's a punishment, I think is just tragically funny. Yes.
Oh, well, I'll see you one and raise you one.
Okay, go ahead.
Your comment, or your response was tragically funny. My response would be tragically immoral. They're willing to spend money on things like jails, which cost millions of dollars.
Right.
But they're not willing to spend any or hardly anything in comparison on treatment. Where if they did spend something on treatment, they wouldn't have to spend so much on jails.
Absolutely.
Amen.
Absolutely. For every dollar spent on treatment, there's at least a $4 return just in criminal cost alone. That doesn't take into consideration healthcare cost, loss of productivity, other factors, and I think it ends up being what, Jason, up to about $11 or something? You know, where can you invest $1 today and get $11 return on that dollar? I don't know of anywhere. I had another thought, and I've already lost it, Ron, but when you were talking about the jails, but you know, jails are big business. Jails are big business. And I want to give you a quote, though, that I heard from a person who's a director of a program over in Cincinnati. When I heard him speak the first time, I knew I liked the man because he said, "I hope to live to see the day when addicts and alcoholics are raised to the level of the aluminum can." Now I'm going to say that again. I hope to live to see the day when addicts and alcoholics are raised to the level of the aluminum can. Now, I don't know if it struck you the way it struck me, but we are willing to recycle and recycle and recycle and recycle inanimate objects, but we're not willing to invest in human beings.
I gotta think part of the reason for that is because, and I'm going to get blatantly political here.
Okay.
A lot of politicians are hung up basically on two sins. And they will do anything about these two sins that the Supreme Court has said we really can't do anything about. but they're ignoring the thousands of sins that we can do something about. They're ignoring the sins that relate to drug addiction. They're ignoring the sins that relate to alcoholism. And those are sins that we can do something about. But they're so hung up on the two that we can't, that they're ignoring the thousands that we can. And with some better choices about how we spend our money, we're going to spend it one way or the other.
That's right.
We're going to spend it on treatment, or we're going to spend it on jails.
Right.
And where do we get the best bang for the buck?
Right.
And it's immoral to do anything but.
The problem is that advocates, lobbyists have been hired to go to Washington and create environments that require the United States to lock up so many people. We have contract. We've privatized the prison industrial complex, and now the United States is fiscally obligated to lock up so many people per year, or the government will get sued. They'll get sued by these companies that own the prisons. So
That's a sad state of affairs.
It is a sad state of affairs.
Very
So
sad.
if that's where advocacy comes in.
Yes.
If we need that same power in DC, we need that same power in Frankfurt, we need that same power locally here on the streets, in the communities, in the nation, in the capital.
That's right. Yes.
Well, and something that I noticed too is that, and something I've just noticed in general, is I feel that a lot of these politicians that are voting on matters like these either don't have the personal experience or don't have the mindset to understand it, to be an advocate, or to just be, I don't know what the word I'm looking for is, but to be understanding of, because I've got a couple of addicts in my family, but even if I didn't, I would still advocate for that because I feel very strongly about it. But there are some people that just are so close-minded to it because they've never had any kind of experience with it.
Right.
And I think that that's where a lot of our problem is, because, you heard, there was, I don't know who it was, one of the guys stood up and said, I've personally experienced it.
Mhm.
We need to push this bill through. This is an
Right.
important bill. And I think if we had more of that, or at least more of, of those advocates in Washington or wherever,
That's right.
it would help.
Well, in real estate, they say location, location, location. I would say for advocacy, and for this issue in particular, or for any issue really that you're advocating for, it's about education, education, education. And a lot of what people do is based on what they know about. Like you said, they've never had the experience, and if we don't teach them about that, and again, I will say, Thursday night, I think you're in for a treat when you hear about how some advocacy and education really did change things in Frankfurt this last legislative session. Okay, so we're at the point now that I was going to go through with you the steps in the process of Casey's Law to educate you about how it works, why it works, and to give you some background so that you can then be an advocate if you choose to for Casey's Law and be a source of information to other people who may need to use it. It's 8:15, Jason. I don't know, do we need to take another break? Do we want to go on into it or what?
What do you guys want to do? You want to get out a little bit earlier than 9 or take another break? It's up to you.
Okay. All right. We're going to roll?
You want to stay? Okay. So
We good?
You think we'd be good to wrap up at 1:45?
Yeah, I want to get home and do homework.
We'll try, Jason.
Okay.
Yeah. Okay, so what is Casey's Law? It's an involuntary treatment act in Kentucky for those who have a substance use disorder. And I can tell you that, yes, it is in Kentucky, but it is also in Ohio. There is a similar bill in Ohio. It's in Senate Bill 117. As I was talking to Ron earlier, they have really deviated from the Kentucky statute, even though I spoke in Columbus and was hoping that it would be more closely modeled after Casey's Law. And I've been contacted by at least almost 25 states now, people in 25 different states across the country asking how they can get a Casey's Law in their state. I just spoke with a gentleman today from Louisiana that was begging for help, and he has nothing in Louisiana. The history became a law on April the 9th, 2004, but it didn't become effective until July the 13th of 2004 because the governor did not sign it, and it was not, did not have any emergency clause in it. That's the KRS numbers there. And of course we know it was inspired by the death of Matthew Casey Wethington, my son. So what does this law provide? It provides a means of intervening with someone who is unable to recognize his or her need for treatment due to their impairment. And we know from hearing the class on treatment, you know how that the two regions of the brain are not communicating with each other. That pleasure center and that prefrontal cortex just aren't communicating. Who can use the law? Parents, relatives, and or friends can petition the court for treatment on the behalf of the person who's impaired. And this is key right here. Regardless of age and without any criminal charges. There are no criminal charges involved here. And it doesn't matter if that person is 23 or 73. It really doesn't matter. And I can tell you, I was in Powell County not too long ago, and there was a lady there who intervened on her father, who was of considerable age, and I think it was the first Casey's Law in that county. So you obtain the petition from either your local circuit court clerk's office. You ask for the verified petition for involuntary treatment for alcohol and drug abuse, otherwise known as Form AOC 700A, or you can go to Casey's website and get the petition. Click on petition and you can print it off. The petition is really basic, names, addresses. The heart of the petition lies in a couple of places. One, where you check how many days of treatment you want. You can check for up to not more than 60 days or not more than 360 days. And what I recommend for people who are filing, especially if their loved one has been in addiction for a number of years, and if they're addicted to things like heroin and other opiates, not more than 360 days. It also asks why you think that person needs and can benefit from treatment, and also why that person is a danger to themselves and others. And you know, really proving that a person is a danger to themselves is not hard. If they are using, they are in danger every time they use of not surviving. So that is a pretty much a given. 2 evaluations are required. One of them has to be by a physician. The other one can be by a qualified health professional, like a therapist, a counselor, a CADC, or another physician, actually, you could get. Those evaluations are required to be notarized, and they have to be returned to court immediately upon completion, no later than 24 hours prior to the court date. So as soon as you get them done, you get them back to the court, and then they're there 24 hours prior to the court date. And what we are telling people is this: go ahead and schedule the evaluations prior to filing the petition. That way you know when your appointments are, and so then when they set the court date, it's not going to be too soon before you have time to get the evaluations done. The petition is filed in the county where the respondent resides, and that doesn't matter if he is homeless there or if he has a place to live there. It's wherever he is living, he or she, I should say. The circuit clerk's office receives the petition and requires that the petitioner sign a guarantee of payment for all court costs. Now, we're finding that here in northern Kentucky, anyway, that you can get your evaluations done and pay a sheriff's fee if you need to, because the sheriff may need to deliver the summons to the individual unless the family member does, in the presence of another adult. And for detox, runs around between $200 and $250. Typically, that can all get done within that kind of range. Then when it comes to paying for treatment, again, there are low-cost and no-cost facilities. We have been using Casey's Law, and actually people are going out of state to other free facilities if they can't get into free facilities here. And what I've found too is that a lot of the no-cost facilities are the longer-term treatment facilities. It's the ones that are short-term that are like private pay facilities. So if you can get a no-cost long-term facility, you are much better off, because as we know, it takes time for that brain to even begin the healing process so that that person can sustain any kind of recovery time. Again, the petitioner has all the rights and all the responsibilities. They have the right to choose the evaluators, the right to choose the facility. They cannot depend on the court to assign a facility. The court is not going to do that. The first case that I knew of was in Boone County. A family took out a second mortgage on their home and sent their daughter to Hazleton in Minnesota. And later they said in a news interview, they did an interview with them on the news one night, and they asked them if they would do that all over again. And they said without hesitation, yes, they would do it all over again. Because, I will have to say this, their daughter did have a relapse or two after she was in that facility, but the good news is she was back on the track to recovery. Because this is what I will say, Casey's Law is what it says it is. It's an intervention. It's not a cure. And we know by definition that addiction is a chronic, progressive, relapsing brain disease. Just like cancer can go out of remission, so can there be a reoccurrence of addiction. So,
Also progressive.
Progressive, did I forget that? Okay, progressive. More about filing the petition. The clerk's office will ask for the names of the evaluators and will provide the necessary evaluation forms. Actually, I have asked the person that manages Casey's website to put those evaluation forms on his site. So you can actually get those forms there without having to wait till you get them from the clerk's office. By law, a court date will be set within 14 days, but may quite possibly be sooner. In fact, an attorney that has worked with families here in Northern Kentucky pro bono, because her son came into treatment under Casey's Law, and I think he has 4 years, if I'm not mistaken, of sobriety at this point, actually had to go to some of the judges and say, slow down on the Casey Law petitions because they weren't having enough time to get the evaluations done. So it cannot be more than 14 days, but it can be less. Making arrangements. Okay, so before you can go into a treatment facility, you have to be detoxed. So it's important to locate a detox if it is not included in that treatment facility. Immediately after the court date is set. So when you file the petition, you get your forms, they set the date, then immediately you need to start calling and making those arrangements so that at this point in time you can tell the place that you're calling, if it's the detox facility. For example, if you call Drogi Detox, Transitions Drogi, you would tell them that I am filing a Casey's Law petition. The court date is set for such and such a day. I would like for a bed to be available for my father, my daughter, my brother, my sister, whoever your loved one is on that date. Then immediately after making that call, you would call the facility and say, I have filed a Casey's Law petition. I have made arrangements for my loved one to go into the detox unit on such and such a date, on the court date, and I would like to have a bed at your facility 7 to 10 days after that. Now, here's the problem that we're still having, and that is there are some facilities that when you call as the petitioner, they are still saying, we need to talk to the person who is coming into the facility. And that, again, is an issue because if we could get the person to call and make arrangements at a facility, we wouldn't need Casey's Law to begin with. So we're still trying to educate people about that. I've said that already. The petitioner has all the rights and responsibilities when it comes to choosing the evaluators and the treatment facility, allowing the petitioner to control the cost, if any. And that has scared so many people away. They've gone to the clerk's office, they've said they want to file a petition, and when they're told that they have to pay, and sometimes they have been told that they will have to pay in the amount of thousands of dollars and they could lose their home, and comments like that have definitely prohibited family members from filing because nobody wants to lose their home, because a lot of people have other children. They don't want to sacrifice their other children for the sake of one, and so they're put in this dilemma of, oh my gosh, what am I going to do now? So it's important for family members to know that there are places available that do not cost thousands of dollars. On the court date, the judge will determine if the respondent is a danger to self and or others, and whether the respondent needs and can benefit from treatment. I will give you an example of when Casey's Law did not work, and that was an instance where a sister was trying to intervene on her brother. Her brother was going through some marital problems, but she enlisted the help of his spouse, soon to be ex, and they were going to do a Casey's Law petition, or they were going to file a Casey's Law petition on him. He convinced a family member that his wife was just doing this out of spite, and so she hired, or the family member hired an attorney to represent him. The attorney convinced the judge that he needed the medications that he was taking, and so that the judge determined then that he really couldn't benefit from treatment because he was going to be on those opiates. The tragic ending of that is that it was thrown out of court and that man passed away. I don't remember exactly, but it was like a month or two later. Based on the evaluations and the request of the petitioner, the judge may order treatment for up to 60 and not more than 360 days. In most cases, the petitioner takes the respondent to the facility that has been prearranged. So that's, I want to go back to this second bullet point there for just a minute, because judges do want the evaluators to agree. If there is disagreement in their findings, more than likely it would be thrown out, or it could be thrown out. And then this last statement here, do not pass go, go directly from court to the facility without making any stops anywhere else, even though they say, I need to go here and pick up that, or I need to do this, or I need to do that. There's no stopping along the way. It's straight from the courthouse to the facility. So what if? What if the evaluators do not agree on the need for treatment or appropriate level of care? Well, I've already answered that question. It could mean that it would be thrown out of court. What if there's no bed available for treatment? Which happens occasionally, and so now that we have Vivitrol available to us, a lot of times I will recommend that the family see about getting a Vivitrol injection for that individual so that they will be protected for at least or up to 30 days to give them time to make arrangements. Often the judge will say, well, come back and we'll go through this again, and we'll be lenient in allowing that person to look for treatment before they're found in contempt of court, because I guess we didn't talk about that, I don't think. I guess I left that out. If the person fails to comply with any part of the process, any court order, the order to get the evaluations done, the order to go to treatment, if they fail to comply with that, they can be found in contempt of court, and that can mean some time in jail. Now, I was criticized for that as well. They said I was trying to criminalize addiction all over again. Not so. What I was trying to do was find a place for that person that would be relatively safe so that they would not be out on the street and continuing to use. I would invite you, if you haven't already watched, I think it was on the blackboard, I think we put that up there, Casey's Law, A Guide for Families, and Judge Grothaus speaks on that video. It's a YouTube video. Casey's Law, A Guide for Families, and he talks about how that works as far as the contempt of court. Different judges handle it different ways. Sometimes judges have held people in jail for quite a few days. Some say you're going to be here until you find find a treatment facility to go to. So because of judges have that discretion that they can use, and so unless they're breaking the law, they can bend it. The respondent refuses to go for the scheduled evaluations. Again, that's when the court steps in, because up to that point, it's pretty much voluntary when you have them, the evaluations scheduled and you ask the person to go for those evaluations. It's only when, if they refuse, that's when the involuntary treatment or the involuntary part of the law steps in and the court can force them to do that. What if the respondent leaves the detox unit or treatment facility against court order? Again, contempt of court. Casey's Law, the myths, the misconceptions, the misunderstandings. One of the things, there are several things that have been said about Casey's Law. One was that it only applies to homeless people who cannot feed and clothe themselves. That has nothing to do with Casey's Law whatsoever. I think some of that confusion could be they've confused it with the mental health laws. Another thing that may be confusing is because we have used the homeless recovery centers a lot for Casey's Law treatment. So that could be where that has come in. You know, the myth about, you know, people having to want to, that involuntary treatment doesn't work. I think, you know, Representative Tom Kerr spoke to that in that DVD. You know, when I'm talking to anyone, you know, I say, let's get real. Let's get real. How do most people get to treatment?
They get arrested.
Exactly. And so, you know, this is what I know too, and that is, it doesn't matter how you get to treatment. What matters is if you stay in treatment long enough for that healing to begin. That's what matters. And Casey's Law is a way of getting people to sit still long enough so that that can start to happen. Again, there's still a lot of misconceptions and misunderstandings about Casey's Law, and we are working on still clearing those up. And I spent, along with three other parent advocates, about 3 hours with people in Jefferson County to try to dispel some of those misconceptions and misunderstandings about Casey's Law. Yes, Jason?
From what I've seen, the biggest discredit to the service is its underutilization.
Yes.
And,
yes.
I mean,
right.
I've been to counties and talked to even local here that they're like, what?
Right.
That exists? They didn't even know it.
Exactly. And it's especially tragic when you talk to family members who have lost a loved one who say, I didn't even know Casey's Law existed. And in the last report that I got from the Administrative Office of the Courts, there were 62 counties reporting that they had either had a petition filed and or judgment rendered, but that's 62 counties out of 120 counties, meaning that 58 counties are not utilizing Casey's Law for whatever reason. Now I can tell you in one county I was told, well, we don't have any resources, therefore we don't fool with Casey's Law. We don't bother with Casey's Law. That's a misunderstanding. You know, thinking that a facility has to be in their county in order for them to be able to use the Casey Law petition. Those are the things that we're still working on. And again, it's been 11 years since Casey's Law was passed, and we're still working on improving the utilization of the law and the education about it. From persistence to empowerment, because as you can hear just from what I've just said, I'm going to have to continue to be persistent. And I was persistent in getting the law passed. You know, I was in it for the long haul. When people said it would take 5 years to get Casey's Law passed, I said okay, and just kept on going. Because one thing that an advocate has to do is not be willing to give up. You have to keep going, because it is often a long haul. It's not, as my husband's doctor said, it's not a race, it's a sprint. And you have to be prepared for that. But with persistence, from persistence can come empowerment. And we started with passion plus purpose plus persistence equals power, the power to make a difference. And I know that Casey's life and death has definitely made a difference in this world. There are people that are living in recovery today that would not be were it not for Casey's Law. It has given hope to the person who has the disease, and it certainly has given a hopeful option to the families who are so distraught and so hopeless and helpless themselves, not knowing what to do. This is just currently what's going on. I mentioned this before. Casey's Law in Ohio passed in 2012. There's a bill draft in New York State for Casey's Law. Family members from about 25 states, and I may not have quite 25 states, actually, it may be a little less than that, but it's almost half of the states across the nation have inquired about how to initiate a Casey's Law, and efforts are being made to institute Casey's Law as national legislation. I have been in contact with an organization called NAMSTL. It's the National Alliance for Model State Drug Laws. That's a mouthful, isn't it? And I have been presenting evidence, if you will, to them by emails and that I'm receiving from people pleading for a Casey's Law in their state, and hopeful that NAMSTL will adopt Casey's Law as a model state drug law so that regardless of where you live, you can have access to that option. And because of passionate, purposeful, and persistent advocacy efforts of empowered people, Casey's Law continues to give those who have substance use disorders and their families hope for recovery. Today, because of Casey's life and death, there are people living in recovery who may not have been had there not been a Casey's Law. And the bottom line is this: hitting bottom isn't necessary and can be deadly. And this is what I say. The bottom line is this: people have to be alive to recover. There's my information. I hope that you will visit Casey's website and also the Facebook page where we are connecting a lot of people all over the country and hopefully moving Casey's Law forward. So thank you very much. I appreciate being able to be here.